Hello, everyone, and welcome to our webinar series. This month, our webinar is brought to us by Good Lawyer, and we have the lovely Pauline Chan here, who's going to tell us all about the Legal Roadmap 101. Full disclaimer, full disclosure, me just being, honest. I've changed up my whole setup, and my camera's right here, but my screens are here, so I'm all over the place. So if I'm doing this, don't worry. I'm just, trying to look at Pauline. I'm trying to figure this camera out. If you've never met me before, hi, I'm Dwaynia. I'm the founder of Canadian Small Business Women. Welcome to the party. Remember to drop your questions in the chat. If we don't answer them now, we'll definitely answer them later because Pauline and I know we do a little Ask the Expert segment. There's a legal edition, and we love to answer your questions. I know you didn't come here to hear me, so I am going to hand everything over to Pauline. Pauline, welcome and thank you.
Awesome. Thank you so much, Dwaynia, and hi, everybody. Thanks so much for having me today. So as Dwaynia said, today we will be going through Legal Road Mapping 101. So in my mind, what we are going to be walking through today is essentially a bunch of the sort of really top of mind legal issues, the basics of for lots of small businesses. And we'll go through quick, like I said, 101. We'll go through the basics, some of the key things that I think that from my experience, I've seen happen with small businesses. So I want to sort of give out those tips and information to you up front. And then, like Dwayne said, feel free to drop questions in the comments and hopefully I will be able to answer all of them. And at the end, I will do my best to leave a little bit of time for that discussion as well. All right, so here we go. This is me. I am a practicing lawyer, and I actually have spent quite a bit of time during my practice time trying to get out of law practice because I wasn't enjoying what I was doing. It was about maybe 5 years ago that I ended up joining this Good Lawyer platform, and I started practicing law across the platform. And this is when I realized that I actually do like practicing law. It's just that I was working with the wrong type of clients and doing the wrong type of work. So yeah, that's me. I've been practicing for quite a while. It's been 13 years. And like I said, my passion is working with small businesses. And one of the things that I actually love the most is to be able to pass out legal information to small businesses and startups so that they get a sense of what they're dealing with and what they need to think about before they get too far along in their business. And of course, because I'm a lawyer, I'm going to tell you that everything in today's presentation is legal information only, and it is not legal advice. So if you do need to seek legal advice and strategy that is specific to your business, I will tell you how to do that. You can reach out to Good Lawyer, and I can tell you how to do that at the end of the presentation. All right, so today's mission, basically the topics that I'm going to go over today, very briefly, we'll start out with the corporation, the corporate structure and how we organize corporations and how sort of the typical tips that I think small businesses and startups should be aware of. We'll talk about contracts, we'll go through employment, hiring, whether it's a contractor or an employee is another big area. Contracts, if I back up for a second, contracts are involved in every single business on all sides. So whether we're talking about customer contracts, supplier contracts, or other types of contracts, they're all over the place in the business. We'll also talk about marketing, a brief little introduction to intellectual property, some privacy, upfront privacy issues, and then also generally compliance with the law. All right, so we have a lot to cover. I will do my best to answer your questions throughout, but if I do mention that, maybe you should just ask you to wait a second because I am going to cover it later. I will let you know, but again, if I don't get to your question, feel free to come back and come back at me with your question and send a message in the comments. So the first topic, corporate structure and organization. For a lot of businesses, this is sort of the key beginning point for most. And the first question I get asked often is going to be, should I incorporate a company or do I run my business as a sole proprietor? Now, for those of you who don't know, a sole proprietor is essentially you're running the business as you yourself, the individual. So if that was in my case, I would be running my business as Pauline Chan, and that's the end of it. It is me as a person, and there's no separate legal entity that lives in front of me, Pauline Chan. So as you can guess, if I had a corporation and I incorporated, I would have a company that I own part of or all of, but I am behind the company. And so, what that means in terms of risk and liability is that if you are operating your business as a sole proprietor, then you are going to be incurring liability personally. So, for example, you go and get a loan from the bank to start up your business and you start it up as a sole proprietor, you're getting that loan from the bank as you, the individual. If you are incorporated in a company and you go to the bank to get a loan for your business, you are going to get that loan from the bank in the name of your business. And so you, the person, the individual, lives behind that company. And essentially, having the company is going to help shield you from certain liability if something were to happen. And so, really, one of the key pro in having a company or incorporating is that it's going to help you avoid some of the liability that might accrue to you personally. Now, if that liability comes to you personally, say as a sole proprietor, what that really means is that at the end of the day, if you do not pay the bank back what the loan amounts that you borrowed from them, then if you're a sole proprietor, the bank will go after you, the individual, and your assets. So your car maybe that is in your name, or your house, or whatever it might be. If you're incorporated as a company and you don't pay the bank back your loan, they will go after the company's assets, whatever other things that the company might have of value that the bank can then use to get their money back. Now, one thing specifically with the bank example, and also actually with commercial real estate, if you are leasing, renting a space, these two examples very specifically, even if you are a company and you're incorporated and you've signed the documents as your company to either borrow the money or to rent or lease the space. Unfortunately, what happens is in both of these situations, what can happen is that the bank or the landlord will say, okay, that's great, but you're a brand new business and we don't have any history that we can rely on. We only know of your personal reputation, but we actually don't know anything about this business. It's a brand new business. There's nothing, no information we can look at to give us comfort that you are going to repay us if you're the bank, or that you're going to pay your rent if you are leasing a space. So instead, what the bank and landlords will often do is say, okay, fine, we will sign this agreement with your corporation, with your company, but we're actually also going to ask you to sign a personal guarantee. So if they ask you to sign a personal guarantee, what that is doing is actually taking the liability behind the company, behind that legal entity of the business, and then to you personally, because you're signing a personal guarantee. So in that case, yes, your company is liable for the debts of the business, like the bank loan or the rent owed to the landlord, but actually you are also personally liable because you have signed that personal guarantee. So in many cases, a company can shield you from liability because it does not allow whoever has a claim against the company, it does not allow that claim to go behind to the person who is behind the company, the individual, except for, like I said, those two cases. Now, another pro on one side and con on the other, is that corporations are more difficult to start. They cost money to start. You do have to pay filing fees. You have to get registered as a business. Now, if you are a sole proprietor, you don't have to do any of those things. You don't have to pay money to start it. You just start your business. Now, if you were to incorporate, you have filing fees and whatnot upfront, but also going forward, you have to maintain what's called a minute book. And so this is essentially the company's record book of everything that has happened. So when you have meetings, you take notes about those meetings and you put it into the minute book. You have requirements to do these annual meetings or annual resolutions in place of a meeting to agree on activities of the company, to appoint auditors, to share financial statements, things like that. Now, these types of obligations and these types of record keeping requirements don't exist necessarily in a sole proprietorship. Now, when I say not necessarily, it's because what I'm actually referring to is you still do have to maintain the revenue, the money coming in, the expenses. And then because at the end of the year, when you're a sole proprietor, you're going to file a personal tax return. If you are a company, you're a corporation, you're going to file a corporate tax return and a personal tax return So you do both if you're a company. If you're a sole proprietor, you're only going to be doing the one tax return. But the reason I bring that up is because while you don't necessarily have the record keeping obligations as a company, you do still have the same record keeping obligations that you are required to do in order to satisfy what CRA needs to do your personal taxes. So it's not that there's no record keeping requirements as a sole proprietor, but there's a lot less than if you incorporate or if you have a company. Now, I think the key thing really to think about here is liability. So depending on the risk of what you are doing in your small business, it'll make maybe more sense for you to incorporate right away, or maybe it'll make sense for you to just wait, see, and go through the sole proprietorship and then incorporate later on if you want to. The risk of your business is something that you need to think through, and I would strongly recommend you do this first. And then if you have further questions, reach out to a lawyer so that you can explain, okay, this is what my business does. These are the risks and liabilities that I see. But then you can ask your lawyer, what do you see? In your experience working with other businesses in my industry or other similar businesses like me, what is the risk that I'm facing? What is the liability? And then that way your lawyer can then take the information you give them, their experience, to give you advice on whether you should incorporate upfront, or maybe it's possible for you to wait and continue as a sole proprietor for a period of time. Now, the example I always give is, for example, if I am going to start selling hair scrunchies, the risk of me selling hair scrunchies, the potential liability that can come back to me selling hair scrunchies is fairly limited, right? It's really quite low. It's just not something that's super risky. Now, on the other hand, if you are starting up a business where you are giving, say, pregnant women, I guess, pre and postnatal fitness advice, for example, then in this case, you can see already there's a little bit more potential risk, a little bit more potential liability if something happens to mom, if something happens to baby, or whatever the case may be. So you can see kind of the two different types of businesses carry different risk. And so when you understand your business and what kind of risk there is, that's going to help you decide better whether to incorporate right away or whether you should maybe you can go ahead as a sole proprietor for a period of time. Now, there's other considerations, but I think the key ones to start thinking of is essentially risk and liability, and then also understanding that it just costs more to start a company and to maintain it over the years versus being a sole proprietor. However, again, the trade-off is if you are a sole proprietor, you're taking on a significantly more risk and liability. So there is always going to be that balance of which works best for your company. Now, shareholder agreements, this is one area that I always will tell my clients, please get a shareholders agreement. If it's not just you and you have another shareholder, please get a shareholders agreement as early as you possibly can. I have seen countless small businesses come to me with a partner that they've been working with for whatever. It could be someone you've been working with for 5 years. It could be somebody you're working with for 5 months. And then they come to me and say, things are not working out. They are going to exit the business, or I'm going to exit the business. How do we do this? And how do we do this? And can we do this in a way that is quick and efficient and all of that? And my first answer is going to be, it depends. But my second answer is going to be probably not, unless everything is very, very amicable. And even in that case, there's no guarantee what will happen when it comes to, well, as usual, money. So shareholder agreements are really, really important. Even if you just get a basic shareholders agreement that talks essentially about it, it's basically just a contract, and it will basically outline for you and your shareholders who's responsible for what. For example, if the company needs more money to be put into it, if it needs contributions from the shareholders, what is your responsibility? What is each shareholder's responsibility? How do shareholders get in and out of the company? And when they say, for example, want to leave the company, like I was talking earlier, or maybe you want to leave the company, how do we value the change in the value of the company from when we started to today, when I want out or when you want out? Now, it's really easy to think that, okay, well, we'll just figure that out later on if we get there. The problem is, like all things, when you get to the moment where you need to figure it out, you may not have the same relationship as you did in the beginning, which means the negotiations on when the negotiations on somebody getting out, how they are going to get out, for what price are they going to get out, etc. All of those things, that discussion is going to be very different at that point than it would have been in the very beginning. So it's always, to me, this is money worth spending. Get it all down in writing, what the obligations are, what happens in case somebody wants to buy your company and your shareholders do not agree and don't want to sell, or maybe you don't want to sell, or maybe somebody wants out and everybody's trying to decide on how much this person is going to be paid for their shares when they leave. These are all things that you want set out in the shareholders agreement. One other thing I just thought of too, as well, is the dispute resolution clause. This is really, really important. It's a way for you to sort of set out with your shareholders. If we get into a situation where we can't agree on something, this is the process that we're going to follow. So one example is going to be, let's say, a dispute resolution clause might say, we are going to negotiate for 10 days on a good faith basis. And if we can't come to a conclusion, we're going to take a cooling off period for 10 days, just so everybody can calm down, do a little research, maybe think things through, get some advice. And then we're going to do another 10 days of good faith negotiations. And if that doesn't work, then we will go to arbitration, and that's the end. Whatever the arbitrator decides, that's what is going to happen. Or we're going to go to court. Whatever the case is, it's going to give you the exact process so that if something happens between you and your shareholders, you can say, okay, I know we disagree. We're both really heated about this, but you know what? In our shareholders agreement, we have a dispute resolution clause. We can't agree right now. Let's do this. Let's do the negotiations, cool off, negotiation, whatever it might be. So what we are trying to do with the shareholders agreement and all of these situations is really, we're trying to plan for the future, whether it looks wonderful, whether it looks terrible, or it's somewhere in between. The point is to get this set down in writing so that no matter what happens, you can always point back to this contract, the shareholders agreement in this case, and say, okay, let's just follow this, let's do this, and it's fair for everybody because this is what we agreed to way back when we first signed the agreement. Now, without shareholders agreement, of course, you can still negotiate any number of these situations and you can negotiate with your other shareholders. The problem is, like with many things, it is just going to cost more money. It is probably going to take more time and effort than if you already had a process set out. Because again, feelings, right? Emotions, those things are all involved now. And there's a history. And so things are just not as simple trying to figure this out later. And because it's not as simple trying to figure this out later, it is just going to end up costing more money. And frankly, as a small business owner myself, aside from my law practice, it's energy draining. You don't have time, you don't have the energy for this. It's so much easier when you have a shareholders agreement setting out all of these processes so that if something goes wrong, you can just point to it and follow it. Certainly, there's still going to be a little bit of stress, but it is nowhere near when you're negotiating essentially in the dark. Now, share structure, this is really commonly something that I think a lot of small business owners don't understand because most business owners will say, you know what, I can go down to the registry down the block and I'm going to get them to incorporate me, or I'm going to go online and find a legal tech company that will just incorporate me. I submit some stuff and then they click, 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 and then I'm incorporated. There's nothing wrong with that for very, very simple and basic incorporations, but I would always recommend that you go see a lawyer, talk to them first, find out if this makes sense for you to do the share structure that comes with these very, very basic incorporations. So when you get a basic incorporation, most typically you're going to get something like one class of shares and everybody gets the same shares, everybody gets the same rights under all of this one class of shares, etc. Now, that's fine if that's going to work for you. However, what also, if you know at the beginning, it is going to be cheaper to help to set up properly. So when I say properly, these are some of these areas that I've listed are things that if you think that this might apply in your situation, talk to a lawyer first before you go get that basic incorporation, just to make sure that this will still suit you. Now, what I'm saying, for example, is I'm going to start with the second point there, family, business, or co-owners. This is the case where maybe your spouse, your partner is involved in the business, maybe you have adult children who are involved in the business, or other family members. Now, in this case, even if it's not a family member and it's just fellow co-owners, what you want to think about is, does it make sense for all of us to own the same class of shares? So when you incorporate, you will get Class A shares, and that's it. Class A shares are common shares. They have voting rights. They get the rights to any sort of leftover assets if the business has to liquidate or dissolve, things like that. Now, If it's the family business, does it make sense then for everybody to get the same class of shares with the same class of rights? Maybe you have adult children who are working in the business, but you're not quite yet ready for them to have voting control or essentially a say in the big business decisions of the company. Now, let's say you're planning on giving them this decision making power one day, but right now you're not quite ready for that. So, this is one of the situations, for example, where it would make sense for you to have different classes of shares. So maybe your adult children, you don't want them to have voting shares. So you give them non-voting shares, which means they get a different class of shares that does not come with voting rights. You, on the other hand, maybe you and your partner or your spouse, you do get voting shares. Or maybe in this case, you're like, you know what, even my partner or my spouse does not get voting shares. They get shoveled into the non-voting share pile with the children. I make the decisions for now. And that's fine. Whatever it is, you want to be able to think through these things in advance so that you can plan for it and then properly incorporate upfront for what you need. Another area too that I will say is if you have employees, let's say you have a key employee who is currently essentially they're building your app for you. They have all of the technical knowledge and background to do this. You have none of that. And so they are a key employee. But in order to keep them, because you can't really pay them cash compensation at quite the same level as, say, other more established businesses, you're going to say, okay, this is what I can afford to pay you in cash, but I'm actually going to give you a piece of the business. I'm going to give you little pieces, employee shares in the business. And instead of being able to give you just cash compensation, I'm going to give you some cash compensation and some compensation in the form of shares of my business. Now, again, similar to the other example I gave, do you want that employee to have voting rights? Maybe, maybe not. Now, if you say, no, I don't really want them to have voting rights, but I do want them to have a piece of the company because that will help motivate them to do their best work. Great. Again, this is a situation where you would need to have more than one class of shares and specific rights that go with certain types of shares, and other shares will not have those same rights. The last example, first bullet there, salary versus dividends. So this is a case where I always like to use my own business as an example. I have two partners. I am in the business part-time. One of my other partners is also in the business part-time, but the third partner, she's there full-time. She's doing this all day, every day. Now, in that case, the full-time partner wants to be paid salary from the business. Me and the other part-time partners, we have our own financial situations that are slightly different, and we don't want salary. What we want instead is whatever it may be, dividends or something else or something else. However it is that we want to get money out of this business, for me and my part-time partner, it's not necessarily the same as the full-time partner. So what we would do is issue shares so that partner A, who is full-time, has class A shares, and me and the other part-time partner, we get class B, class C. What this means is that, let's say my full-time partner says, you know what, this month I want, instead of salary, I want all dividends because it makes sense, or this year, I want all dividends because it makes sense for my financial situation and my tax strategy. Okay, great. So we can issue class A dividends, and that way me and the part-time partner, we don't get any dividends this round. It's only dividends being issued to the class A shareholders, which is the full-time partner. Now, let's say the opposite. She takes all the salary and then she's like, I don't need dividends. Me and the other part-time partner are like, okay, actually dividends makes most sense for each of our own tax strategies that we came up with our own accountant. We would like to be paid dividends. So in that case, the company can then say, okay, we're going to issue dividends to class B and class C only, which means class A is not going to get dividends. And we are class B and C because of all of our different tax situations. So you can see that if we had incorporated with only class A shares, the problem becomes now every time we issue dividends for class A, all three of us are going to get dividends whether or not we want them. So again, it's not that there's anything wrong specifically with any one of these pieces. It's more just that we want to be sure that you're doing what's right for you. If you already know that, let's say you've got this key employee, or maybe you already have partners that you know that they're going to want dividends that you don't, or it's a family business. These areas are areas that if you know something upfront, then it makes sense to set up your company with the proper share structure so that when you do need to move, you can move quickly. And this especially comes into play with angel investors or investors of any type really into your business. If they're ready to invest and you're like, oh my gosh, I need to go change the share structure of my business because it's not going to suit what the investor needs, then you need to now go seek the help of a lawyer to get this all cleaned up. And then now you're in a rush and you're panicking and your investor's wondering why this is going to take why this is taking so long. So it's always better to get it set up properly if you can at the beginning so you can move fast and without as much effort when that time comes, if it comes. Oops. All right. So next piece is commercial contracts. So really, this is just every business is contracts. It's contracts all over the place. The first two contracts that I list here, goods and services, this is going to be most of the time, we're talking about customer contracts. Now, it could be as simple as your customer clicks, click, 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 click on your website, and they purchase something that you ship to them after they make the purchase. When they're going through that process of clicking, agreeing to your terms and conditions, that is a contract. If you're selling services, it's the same idea. They go through, they book you for, advice, for an advice session, or they book you for the initial consult for their fitness regimen or whatever it might be. Again, same idea. As they click through your website or as you're speaking and you're sending your terms and conditions and contracts to them, this is your contract. Now, what's important and I'll go through the last category. Supplier contracts, this is anything from if it's a customized supplier, so if somebody is manufacturing something specific for you, there's going to be a contract there. If you are buying parts that go into your product, or you are buying a service from a subcontractor who provides part of the service that you provide to your customer, these are all supplier contracts. So any sort of inputs that go into your business, whether they are goods or services, that's one type of contract. And then you've got the out contracts, which is the goods or services contracts that go to your customers. Now, it's really, really important to get these reviewed both by a lawyer, but actually by you. So one of the most common things that I hear from a lot of small business owners, oh yeah, well, I didn't have any negotiating power, so I didn't even read it. I just signed it and sent it back. Or I didn't have time to read it, or, I skimmed it and I think it's good, so I signed it and sent it back. This is not always going to be a problem, of course. It really depends on who you're doing business with. It really depends on what the context of this contract is inside of your business. So, for example, the example I always give is if you are dealing with a customer who is going to be purchasing 90% of your inventory over the next year on an ongoing basis, this is a really important contract to read through very carefully and negotiate as much as you can, regardless of who the other party is. Now, if this business, on the other hand, is maybe 5% of your revenue for the next year, it's still it's still an important number. It's 5% of your revenue, but then it's actually also going to tell you, okay, it's 5% of revenue. These are the things that I am not willing to negotiate with this customer, because they are 5% of my revenue. The same thing does not apply when the customer is 90% of your revenue. Maybe in that case, you're like, okay, I will let them have a lot more of the things that they want, and I won't push back as hard on some of the things on the contract that I want, because again, this is a big customer, they're important for me, and I really want to do everything I can to get this contract. So there's nothing wrong with that. It's more just, again, read the contract. Think about it in the context of your business. What does it mean for your business? Is it really important for your business? Is it kind of, sort of, or is it not really that important? Another thing I would say, template contracts are everywhere. They're all over the place out there, and you can probably even copy paste one from potentially a competitor's website if they have terms of use and things like that. The only thing I want to say there is really that is only a starting point. It's very, very important, no matter what type of contract you're looking at, to have it customized for your business. One example that I give always is that if you have let's say you have a agreement with your manufacturer that says that they give a warranty of 12 months for that product that they've manufactured for you to sell to the customer. You go and grab some template contract you got from somewhere, or you copied it from a website somewhere, and you use that and you fill out some of the blanks and then you send it off to your customer. However, that contract specifically gives the customer a 24-month warranty for the product because it wasn't customized for your business. What's happened now is, as I'm sure you can see, you've given the customer a 24-month warranty, but when you look back to your manufacturer, they've only given you a 12-month warranty. So that gap of 12 months is unfortunately now your responsibility and the liability of your business. And so you really want to make sure, this is a very basic example, but there's a million different other things that really need to be customized for your business. Cash flow, payment terms, these are some of the more business minded terms. And these are really, really important to understand. What are you offering to your customer, for example, but also on the supplier vendor side, what are they offering to you? You want to make sure that these contracts match up the best you can, but also you want to make sure that it's customized to your business so that you know when you can invoice, when you should get paid, and then how that invoicing and payment schedule is actually going to work with your invoices and payment invoices from your manufacturer and payments to your manufacturer. So again, there's gaps between contracts from your supplier potentially to your customer, but even if there wasn't those gaps, you need to be sure that the contract is going to do what you need it to do for your business. Read it, think about it in the context of your business, and then talk to a lawyer. Tell them what you've been thinking about, tell them what the problems you see are, and then they can also add to that their knowledge of the written laws about, if there is something that does apply to this contract, they can tell you about the written laws about it, but also they can look up and or tell you about their experience with the case law that also plays into these contracts. Last thing I'll say, always negotiate. Lots of small businesses will say, well, I'm just a small business, they're not going to negotiate with me, so I'm just not going to bother. That's not true. Even the bank, you go to the bank and you try to negotiate, you know that sometimes they will say, okay, well, I can give you a better deal, blah blah blah, whatever it might be. Always negotiate. The worst case scenario is that they're going to say no, and if they say no to you, that's fine. Now you have to decide, am I willing to move forward on this contract even though they won't change this, or am I not? Maybe it is something really important. As you read through the contract, mark down those things that are high importance to negotiate, low importance to negotiate, and what's medium. And then you can start to understand, okay, this is important, this is not so important, but you can use these as bargaining chips to negotiate with the other party. All right, so employment, another area for businesses. The key thing I want to talk about here is that when you're dealing with employment, there's always going to be the tension between who is a contractor and who is an employee. Now, unfortunately, of course, the consequences of misclassifying a contractor, you misclassify an employee as a contractor, there can be serious consequences under the law for this. So a contractor is what I would say is a contract for service. Employees are a contract of service. Slightly different. Now, employees they owe a little bit of a duty of loyalty. They work inside your company. They have one job, and that one job is to do the work that you ask them to. They might have a little side hustle business and stuff, and or something small like that. But essentially, they are your employee. They do their work for you. They owe a duty of loyalty to you. And in exchange, you have employer obligations to these employees. So what that means under the law is you potentially need to do deductions. So the EI and CPP deductions and remittances to the CRA on behalf of that employee, or you may need to give them vacation time, or you need to pay them minimum wage, or. So it's all of these things that we typically hear about in the law that apply to employees: overtime, minimum wage, vacation, and a whole bunch of other things. Now, contractors do not have those same requirements. Contractors are essentially their own business. And so if they are performing some sort of service for you, it is under a contract of service. So they're providing you contract for service, sorry. When they provide you this contract for service, what it is really saying is, okay, here's the services that the contractor is going to provide. This is the pricing for it. And then basically when they're done with that service, that's the end of it, they're out. Contractors will also generally have the ability to have profit or loss in their business. You probably are not their sole and only client. They use their own equipment potentially instead of asking you to use your equipment for their work. If you think about it in the context of a traditional employee, employees will often get a company laptop, they get a company cell phone maybe, and they have to do their work according to the employer's procedures. They have to follow those rules, whereas a contractor doesn't necessarily follow those rules. You pay somebody to design a website for you as a contractor, they're going to do whatever they do to build that website and give it to you. They don't have to follow your rules exactly for how you go about doing those things. They may take your input on, say, fonts and colors and pages and all of those things, but that's it's different in that they're taking the input to design something for you that matches what you want, versus employees who are like, if you're going to book a service, you click here, you do that, and you always have to check with this group and that group. So there's different rules that apply to an employee that typically don't apply to a contractor. Now, employment policies. So this is also one area. A lot of small businesses will say, okay, I got my employment agreement, sent it out, it's good. What I always want to let small businesses know is that it's really important to have employment policies. These also form part of the terms and conditions of employment. And so there's lots of things that go inside of employment policies that are slightly easier, smaller things that you tweak on a regular basis versus the employment agreement, which you generally don't tweak for small things here and there. It's the employment agreement, this is what applies, this is how things go, and then the policies that kind of live on top of that. So policies and procedures for all the different things of how you do the work that you do, where you do the work potentially, like we're talking about remote work, hybrid work. How do you protect the confidential information of the company? Health and safety. This is the way you need to perform your job so that you don't injure yourself, so that your workers aren't injured. All kinds of different policies. There are some that are required by law, and it's really important to make sure that you have those in place with your employment agreement so that when your employee signs the agreement, not only do they agree to the terms and conditions that are in your employment agreement, but they agree to those employment policies as well. Equity incentives, we briefly talked about this earlier. So this is really just the part where you're dealing with an employee and you cannot necessarily pay them the cash compensation that you want to be competitive, to be a competitive employer. But at the same time, you can say, okay, well, here's your equity incentive, which is that here are some shares that I can give you from the company based on your performance or based on whatever it might be. Essentially, you're giving away a little piece of your company to an employee so that it motivates them to do their very best. All right, so next piece is marketing, really big, important piece for all businesses, including small businesses. Now, when you're talking about marketing, it's really important. Almost all businesses these days have a website, and on your website, yes, you are marketing to the customer, but there are important things that you need to make sure that are included on your website. Now, terms of use is what I talked about earlier. So depending, for example, if I'm giving pre and postnatal fitness advice on my website, I'm going to want to make sure that I have terms of service, terms of use on the website that will say, hey, person who's come to my website, if you're reading my blog and you're reading about this pre and postnatal fitness advice, just know that I am not a medical professional and you should seek advice. And I am not saying that you will get any kind of results from reading my blog and taking my advice. Read it at your own risk, do the things at your own risk, go get advice. I'm giving you no warranty about any of this. So it's important, for example, to set out some of those things, even though you don't generally expect to have terms of service or terms of use with somebody who's not a customer. However, all kinds of people end up at your website. And depending on what is going on your website, you want to make sure that you have the right disclaimers and sort of protection for you as the business, depending on what could potentially happen when people access your website, use your website. Privacy policies, we'll talk about a little bit later, must have for everybody who is collecting personal information of customers or any visitors to the website. If that is such a case, then you absolutely should have a privacy policy on your website. We'll talk about that later. Social media. This is another area where there's a lot of social media out there, and a lot of companies now will have influencers or partners and whatnot to help promote their products now and services. Now, if this is the case with you, there are rules and there are contracts that you're going to want to have in place with whoever your influencers are or other partners who may be helping you market your products. It's very important to have that kind of it's very important to have that kind of contract to specify what is the relationship. We'll talk about this a little more in the next slide. Email campaigns, this is another area that a lot of small businesses will say, okay, well, I have a whole email list and I'm going to send out a marketing promotional email or newsletters or whatever it might be to whoever I have on this email list. Now, just make sure there are rules around it's basically Canada's anti-spam legislation. Canada anti-spam legislation, CASL, otherwise known as. And CASL, there's some fairly strict requirements. It's actually one of the more stricter pieces of legislation in Canada as compared to the rest of the world. However, the point is that if you are going to be sending out marketing messages to an email list that you have in your database of sorts, please be aware, please check out Castle, please talk to a lawyer about it and understand what your obligations are, how you can get consent from people to opt in to your email campaign or potentially allowing them to opt out. There's different types of applications of opting in, opting out, express consent, implied consent under the law. And it's important to understand this because there can be some very serious fines for businesses that do not comply. Now, further on in the marketing chain, so you'll also want to think about who's doing the selling. So in some cases, you have an employee working for you inside of your company whose job is to do sales for your business. Okay, that's one situation. You also potentially have contract salespeople. So what that means is contract salespeople are just going to be exactly that. They're working for you on a contract, but also they could potentially be working for your direct or indirect competitor. This sounds really, it sounds unusual, but it actually isn't really. If you think about, for example, the insurance industry, that's exactly what brokers do. Brokers represent several different insurance providers. And when you go to them to buy insurance, they will say, okay, I've got, these different products and from these different companies, and these two seem to fit you the most. Would you like to purchase one of these two? So it's the same idea with a contract salesperson working for your business. They may very well be selling your products alongside either selling competitors' product or somebody completely unrelated. But the bottom line is they're a contractor and not an employee. Like we talked about earlier, when you understand this, it's really then you also understand what type of contract you need for this salesperson. There's also potentially agencies, sales agencies that will basically assign people within their agency to sell your products and services, whether it's the same person every time or not the same person. So again, your contract is different now because you're now selling by way of the sales agency. So your contract will be you, your corporation, with the sales agency, and then they just assign whoever they want in the business to do the sales. Again, different sort of contract because in this case, you're talking about a supplier. They're essentially a supplier of salespeople in some ways. And so the contract again will be a little bit different. Understand what this looks like in a business, in your business, and then talk to a lawyer. How will they get paid? So there's all kinds of different ways. It could be cash compensation, of commissions, hourly rate, a mix of those things. It could be equity compensations. That's something that would be more common for small businesses and startups. Again, just like the equity incentives that we mentioned earlier, we're talking about salespeople who work for you, partially cash compensation and partially equity. So then they're actually getting ownership and shares inside of your business. How do you distribute your products and services? Are you doing this directly, i.e. your customer comes to your website, they buy off of your website, and that's the end? Or is it that you're selling through a distributor? Or are you on a sort of e-commerce platform, for example, like Amazon? So if you are on one of those types of e-commerce platforms, the contract again is going to look different. If you're selling directly to your customer, there's a contract between your business and the customer. If you're selling through Amazon, you're going to have a contract with Amazon, but you will also have a secondary contract potentially with your end customer. And so it's, again, important to understand what that marketing and sales chain looks like so that you can then understand what types of contracts you need to protect yourself from all the various things. Now, it's not necessarily also just about protecting yourself. When you sell through, say, like an Amazon, then what you're thinking about now is, okay, Amazon has certain terms that they require in their contract with me. They have certain terms that I have to put those terms into my contract with my customer. So it's not just about protecting yourself, but it's about understanding how there can be flow through between a contract with you and Amazon, and there's flow through things that need to go into your contract with your customer. So it's very much kind of like that manufacturer and customer contract I was talking about, where there was a 12-month warranty here, but there's a 24-month warranty, and now over here, and now there's a gap in between. It's the same idea. If you're required to include certain provisions in your customer contract because of your contract with Amazon, then again, it's important to understand that and make sure that you meet your obligations under your contract with Amazon. Now, other ways to sell, the only thing that I will mention here briefly is that we're talking about licensing, potentially franchising. So franchising is essentially you're selling an entire system to another party, your entire system to another party, so that they can duplicate it, and then they pay you whatever that franchising fee looks like. So if you think about it, that's a lot like McDonald's. Every McDonald's you go to in the world essentially runs exactly the same. And so they're selling the entire system, all the branding, everything is the same. When we're talking about licensing, really what you're talking about is just the brand. So you're just licensing the brand. If you have built up so much goodwill and recognition with your brand, you can license it to others. And what that means is you're just going to allow them to use your brand for whatever they are selling, but you're not selling the system. So what that means is how much control do you actually have over what they are doing if it's the brand and not the system. Again, depends on where you get to one day. These things are important. But again, if you have plans to get there, think about it now, and you can get these things set up in advance so that you're ready to go, or that your contracts already cover the situation when you get there. All right, intellectual property. Now, I am going to very quickly tell you that I am not a intellectual property lawyer. I know just enough to give you the very, very basics. And so I'll walk you through this, but I'm going to tell you right off the bat, I am not an intellectual property lawyer, so feel free to seek the advice of somebody who is. Okay, so for trademarks, essentially you're looking here at brand, logos, words, symbols, slogans, letters, numbers, all kinds of those things, shapes you can have. Non-traditional also includes like sound, maybe a scent or a shape. These are sort of the typical things that help you identify a product. Now, trademark exists the moment you use it for the purpose of distinguishing your goods and services from another's goods and services. So trademark just pops up the moment you start doing it. Now, however, you can also have trademarks then that are registered and trademarks that are not registered. Certain rights come with trademarks that are registered, which you do not have access to if you do not register the trademark. Now, there's lots of different ways that you can come up with a trademark, whether it's just simply that you created this logo and now you started using it, or maybe you created a tagline and you started using it. The key is you have to start using it. If you've never used it, you've never put it anywhere, that trademark does not exist. Like I was talking about earlier, you've got registered trademarks and unregistered trademarks. Registered trademarks come with more rights. Once they are registered, then they last for 10 years, like it says on the side. You get 10 years from the date of the registration, and then you can continue to renew indefinitely for 10 years at a time. When you apply for trademarks, there's different grounds that they can be rejected, but essentially working with a lawyer through this process is going to help you understand the ways that, because there's a bunch of law and case law behind it that will tell the lawyer, okay, what you're trying to do is probably not going to work, but if we tweak it like this, you might be able to get that registered. So it's really important to get the understanding before you go ahead and start using your trademark, so that if you do need to change it, you can just change it now before you start using it. Again, you can probably fix this in 5 to 10 years. The problem is you now have all this brand recognition and goodwill that might be associated with your trademark, and unfortunately you have to change it. So again, doing it up front is going to save you money and time. Now, lots of different ways. One thing I would suggest that you can do without a lawyer is you can go to the Canadian Intellectual Property Office website, check it out. There's a database of pending and existing trademarks. So you have a look there. You can also do just a general Google search for your trademark just to see if there's anything else out there that might conflict with yours. And then a trademark search, which is a specialized specific trademark search from a third party. Now, do these things and you can get a pretty good picture. But again, at the end of the day, talk to the lawyer, because again, just because you found these things does not mean that you can use your trademark. The lawyer will have more insight for you as to what's been rejected before and what tends to work well when you're applying for a trademark. Patents, it protects only inventions that meet certain requirements, and it's a limited right that is granted by the government to an inventor to stop other people from making, using, or selling your invention for a limited time period. It doesn't actually give the owner the right to practice the invention. It only gives the owner the right to stop other people from using the invention. Now, it's up to you as the patent owner. If you do get a patent for your product, it's up to you to monitor misuse and then enforce your rights by, again, seeking a lawyer and filing an infringement claim if you need to. Now, the 3 points that I was going to say to get a patent is that your invention has to be new. So it cannot previously have been disclosed to the public. If that happens, then it is not new and it is no longer eligible for protection. Second, the invention has to be inventive i.e. it cannot be obvious and it cannot be obvious. And so this is determined on a case-by-case basis, and it is subject to case law. So what happens is when you talk to a lawyer about whether you can get a patent, first they'll talk to you about it being new, and then with the not obvious piece of it, they will look through case laws with similar patents and products as you, and then say, okay, so in these past times, these certain patents were not accepted or were rejected because they did not meet the criteria of not obvious for these following reasons. And so it's really important to understand this from a lawyer before you go ahead and file for a patent. Third piece is that it has to be useful. So it needs to be functional, and there has to be some sort of operation in that it is actually going to be usable and helpful and useful. Now, meeting these three requirements is not, again, as easy as it seems because there is case law behind it. And there's certain sort of practices that lawyers who work with patents will do so that they can make sure that they protect you during that period when you file a patent application. The moment you file a patent application, that information is available to the public. Anybody can look at that. The problem is it's not new anymore, is it? Because it's been disclosed because of the patent application. There is a grace period where it will still be considered new if you file for a patent application. During that grace period, it's still considered new as long as you complete the application during that period. So you can see the timing of how you do this is very, very important so that you can stay within that grace period so that even if you have disclosed something, it still remains new under that grace period. So timing is very important. Now, copyright, this applies generally it applies to author of literary works, artistic works. So we've got books, articles, blogs, computer code, photographs, paintings, whatever it might be, things like that, essentially. Now, the moment you create an original work in tangible or fixed form, you have copyright. It's automatic and you don't have to register it. So it's kind of like trademarks. It exists as soon as it's available, as soon as it's being used for the purposes of distinguishing your service or good. Now, again, just like trademark, registered is better than unregistered because unregistered, you can run into problems with enforcement. And it's also can be sometimes difficult to prove that somebody has used your trademark or stolen your copyrighted work. Because when did this actually come up? When you register it, there's a specific date that shows up where you have the trademark or where you have the copyright. When you don't register it, it can be more difficult to prove. And then the last few pieces here, I'll just mention quickly. We've also got industrial designs that's similar to a patent, but really this is more about the design of the thing, I guess. Trade secrets, that's exactly what it sounds like. It's a secret. And so the moment somebody knows about the secret, it's no longer a trade secret. Last piece I'll bring up, confidential information is much broader. That's going to cover just about everything. So it could be the product, could be the services, could be your marketing plan, it could be your financial information. It's basically all the confidential information of the business. That's the broadest category. Everything else that I've listed here is a little bit more specific than just confidential information. Now, one good or one service can potentially have various parts, various pieces of intellectual property. So, for example, the Coca-Cola bottle, or the Coca-Cola really, the Coca-Cola itself, that's a trade secret recipe. The bottle, I believe there was potentially a patent on the bottle because it was inventive, it was different shape, and it actually had use because it was good for transportation, better for transportation because things didn't break as easily. The Coca-Cola also has their trademark logo on there. So you can see that one product can have several different pieces of intellectual property, and it's really important to protect this upfront. You protect it by putting it in your contracts between your employees and your contractors, saying you will not share this information. You do not have a right to use this information or this intellectual property in any other way. If you are an employee, if you improve on the invention or you improve on the thing, I, as your employer, as the company, I own that. Even though you came up with the improvement, I own it because you're an employee. Or even if you're a contractor, I own it. Or you own it, but I get to have a license to use it forever and forever. Also through these other contractors, vendor suppliers, again, how do you protect your IP? If you've got this product that you're asking a manufacturer to create for you, how do you make sure that they're not sharing that information and the process of manufacturing with others, whether they're competitors or not. Last thing, internal processes and procedures. This is one I always say I will talk about in the context of a trade secret. So the worst, usually it's not necessarily true that your employees are the ones that are sharing this information in a malicious way. Often what can happen is maybe you have trade secret recipe for your beverage or for your food item, and then your employee takes their laptop to a coffee shop to do their work. They connect to the open Wi-Fi that is available at the coffee shop. If somebody were to steal that recipe off of the employee's laptop through the open Wi-Fi, that is no longer a trade secret because that information is now out there. And so just like that, your intellectual property has essentially been destroyed in that case, just simply because of a bad actor on the other side who hacked into the Wi-Fi and, well, who didn't need to hack into the Wi-Fi, I guess, because it was open, but they hacked into the computer and stole that information. So this is the part, this ties back to those employment policies, which would protect somebody in this case, for example, by saying, hey, when you work remotely, that's totally fine, but you need to make sure that you have Wi-Fi and protection on your Wi-Fi that meets these following requirements so that our trade secrets cannot be stolen. So your processes and procedures in your business can do just as much to help protect you and protect your IP as having all of that written into your contracts. Have it all written into your contracts, but at the end of the day, you also need to make sure that practically what is happening on a day-to-day basis is actually going to help you do the same thing. Privacy. Everybody needs a privacy policy if you are collecting personal information of customers or suppliers or whatever that might be. Now, think through this when you are thinking through the privacy situation in your business. Map the data and where it's going to cross borders. So when my customers give me their credit card information and their date of birth, where does that information go? Oh, well, I store it all in the cloud. Okay, who is the company that is providing you the storage services in the cloud? Where is that company located? But actually also, where are their servers located? Are those servers in Canada? Are they in US? Are they somewhere else in a different part of the world? Whatever it might be, we're not judging it. It's essentially that, okay, if this is what's happening, we need to inform your customers that this is potentially where their data is going. It also helps you understand where the potential risks are, if depending on where you store it, depending on what the company's practices, who's storing your data are, etc. Now, designing for privacy is something that I cannot recommend enough. Whatever it is that you are selling, when you design that for privacy, it means that you don't have to go back and redesign your product or redesign the storefront or whatever it is. You don't have to redesign it when you find out, oh no, I'm not meeting my privacy obligations. So designing for privacy, again, getting a sense of what the requirements are for your business before you get designing is going to help you, because then you don't have to spend money to go back to the drawing board and fix things. Privacy due diligence. This is applying to your vendors and your suppliers. This is very much that you have somebody who's storing the data for you. Find out where they're storing the data. Find out what their privacy activities are. How do they protect the information? Where are the servers? What do they do to back up that information should somebody get into their systems? Privacy policy. Like I said, required for everybody. Privacy policy addresses essentially what you are doing with the information, what you are collecting, why you are collecting, and how you are going to deal with the situation should somebody hack into the system and get someone's personal information. Privacy policies are one of those things that all the time I hear from small businesses. I copied it from my competitor. They had it on the website. I just copied it because we do the same thing. If that was true, I'd be okay with that. Often, unfortunately, it's not. What you are doing inside of your business is often quite different than what your competitors might be doing. So if your privacy policy is exactly the same as theirs, but you're not doing everything internally the way they are doing it, then what you're potentially doing is saying, oh, I'm doing all these things, but you're not doing them. And then there's things that you're actually doing, but you don't have it in your privacy policy. If the privacy regulator comes to you and says, I would like to see your privacy policy, that is going to be a problem. They are going to ask you, are you doing these things because you say you are in your policy? You will say no. Then you will also say, oh, there's these other things that I'm doing. And they say, well, that's not in the privacy policy. So that is a problem, and you can potentially get fined for it. There can be, and when you are fined for it, they do publish this type of information publicly. So it's not a good look for your company if others are looking at doing business with you and they see this on a privacy regulator's website. This is part of the due diligence process that you do anytime you're doing business with anybody, right? And so know that if it is out there, potentially your business partners, customers, whoever it might be, can potentially see this information. Cybersecurity data breaches, this has always been a problem that has been growing by leaps and bounds ever since the internet started. But COVID has really just made that diagonal line go straight up instead. So cybercrime is at an all-time high. It is not a matter of whether you are going to be hacked or have a data breach. It is a matter of when that is going to happen. So the best you can do is, when you do all these things, map out your privacy, map out the data, know where it's going, do your due diligence on your vendors and how they protect the information you give them. Map this all out, because this is going to help you in the event of a breach. If there is a breach, most of the time you do have to notify the regulators. They'll do an investigation. And then potentially you also have to notify your customers, which is the part that actually hurts most businesses the most. It will help you so much if you can understand where the data is going, what's happening with the data, so that if something bad does happen, there is cybercrime, there's some of your data gets hacked, you will immediately be able to point out, okay, this is where the problem happened, this is how we can deal with it, and now we can speak to our customers and say, hey, this is what's happened, we've done these following things to clean the problem up, and then we're also going to offer you whatever credit monitoring for a year to help out, and we are so sorry. Privacy compliance regulators, like I said, the regulators can come to any business's door and say, hey, let's see how you're complying with the privacy law in your jurisdiction. They can do this anytime, any place. And unfortunately, like I said, if it does not go well for you, this stuff is available publicly. And with cybercrime being at an all-time high and really no end in sight, we are now staring down the barrel of updated legislation, both federally and in most of the provinces across the country, that is going to become more and more strict. It was always going to go this way, because unfortunately criminals exist online as well. And in fact, it's probably the crime of the future, because it is that much more lucrative, unfortunately. So take care of your privacy, talk to a lawyer, talk to a privacy consultant. Last little piece, compliance. So key risks for your business. It's not always about protecting your business from risk, because you're a small business, you're a startup, you're an entrepreneur, you accept a certain level of risk. However, find out what those key risks are for your business, and then you can decide which are the risks that you care most about, and which are the risks that you're like, I'm willing to live with that. I don't think it's such a big deal. Whatever it is, make the decision with your eyes wide open, get the right information, and then you can decide what you're going to do. So some of the things that I talked about earlier. So if you've got an e-commerce store where people are giving you the credit card information, privacy top of mind. If you are in a situation where you're selling lots of goods to somebody and there's a warehouse that holds all of your goods, you're going to need to be thinking about occupational health and safety. Even if it's not a warehouse situation and you've got workers that are, maybe you've got, 5 or 6 people who do sort of like a call center style sales with people, or following after sales service, things like that. Again, occupational health and safety. Do they have enough light at their workstation? Do they have proper chairs? Are the cords a tripping hazard? Things like that. Food and drugs. If you're selling any sort of food, beverage, or especially with newer companies, cannabis type companies, you want to be sure that you are following the legislation that specifically applies to food, health and wellness products, or say cannabis products. You need to make sure, because there's very specific laws that apply to certain areas that, again, if you speak to a lawyer who has some experience in your area, they're going to be able to tell you right away, okay, your product, I've dealt with this before, these are the types of laws that apply, these are the things that you need to set up in your business in order to make sure you meet these obligations. Securities, anti-money laundering, this is typically going to apply to any kind of fintech. If you're doing any kind of money transferring, deposits, any kind of things like that, you're going to be looking at some very strict regulations on securities and banking. So make sure you talk to a lawyer about that. If you've got any kind of goods and services where you have to import, export things, be very careful again. I think the most common right now is that is Russia. So it is very difficult to export and import and do any business with any Russian companies right now. So watch out if you are doing if you are importing anything for input into your goods and services, make sure you talk to a lawyer, understand what those rules are so that you can make sure you don't run offside of these rules right off the bat. Or even down the road, you can start creating those processes and procedures inside of your business to avoid these problem areas. All right, that's it for me. I'm sorry I went over time, but I hope the information was useful. At the end of the day, really, I want you to come away with this knowing preventing problems is cheaper than correcting them. So get the advice and the strategy up front, and you won't have to go back and fix it. That being said, it is possible to fix the vast majority of problems, but it just ends up costing more money if you have to do it later rather than doing it upfront. Focus on the risks that are specific to your business. Know your business. Talk to a lawyer. Tell them everything about the business. Tell them all the ins and the outs, who your suppliers are, who your customers. Tell them. Focus on the risks that are within your business. Yes, we all have competitors that we can copy and paste things from, but again, we don't know what's going on internally inside of their business. So make sure you know what's going on inside your business and then talk to a lawyer, get their advice specific to your business. Last thing, it is a living situation. Your business is a living entity. This means it's going to continue to evolve over time. So just because you have a good template today for a contract does not mean that it's a good template for tomorrow. Make sure you check in, continue to get strategy, continue to get advice before you change things inside of your business or for a customer or whatever it might be, just to make sure that you're catching all those things that have changed. Also, laws change over time. Case law is coming out every day about all kinds of topics. Laws are being changed all the time. We need to bring the both together. Whatever's changed in your business, whatever's changed in the law, let's bring those two together so that you understand, okay, here's a new risk, here's an old risk, here's a changed risk, whatever it is, and then you can decide what you care about and what you don't care about. And that's it. So here are a few of the lawyers that we have on the platform. They are like me, they're solo practitioners who practice on their own. They have their own law practice and they're very wonderful lawyers. They just don't have the marketing behind them that some of the really big law firms do, nor even the small firms. When you're on your own, it's very difficult to be doing the work, but also trying to market your work and doing all of that. And so this is what Good Lawyer does for solo practitioners and small law firms. We help give them the power of the big firms when it comes to marketing and all kinds of other support. But the bottom line is these lawyers are just as fantastic as any other lawyer that you might run into in a big firm. So this is really just talking about what Good Lawyer is. I'll very, very quickly give you the gist of it. I used to be law firm Larry. I worked at a big firm. If you want me to do work for you, I'm going to need to ask you for a retainer first, or essentially a deposit, because I don't know if you're going to be able to pay me. I don't trust that. So I'm going to ask you for a deposit of $5,000, $10,000. Most small businesses can't afford that. On top of that, I'm going to give you an hourly rate. As I do your work, I will mark down my time, and then at the end, I will send you a bill. I can't tell you what that is upfront. I'm only going to know when I finish all of the work at the end and send you that bill. As a small business owner, it's basically impossible to plan for something like this. And of course, you're going to get the bill, and then you'll be like, oh my God, I don't know how to afford this. Good Lawyer is different in that every lawyer that you work with on the platform will give you a fixed fee upfront. So they will tell you right away how much it's going to cost, and then you can make the decision. Can I plan for this? Can I budget for this? Can I make this work? Okay, I'm going to go ahead. There's no surprise bill at the end of it. Whatever they quote you is the price. And so that is the main difference. I would say that for most lawyers, they prefer, frankly, to work this way because it allows us to be more efficient. I don't know that there's certain lawyers I think that will never change, but that is just a legal profession thing. But frankly, for clients, this is really, really unusual. Until Good Lawyer came around, fixed fee services are very, very rare. It's always going to be the billable hours. So check it out. You can decide, again, once your lawyer gives you your quote, if you want to go ahead or not. Okay, and then that's all for me. Thank you so much for attending today. And as part of the community, we're going to offer you $100 in credits with Good Lawyer and a free initial consultation. So the initial consultation, you don't get any strategy or advice, but you do get to meet the lawyer, find out their experience in your area, get sort of some general legal information about what they think about your business and whatever the topic is. And then if you do want to go ahead and book a legal service with a Good Lawyer, then you can use that $100 credit towards any legal service. And that is it. for me. Does anybody have questions for me?
OMG, that was a lot of information. I know you all have to absorb it. If you have any questions, now is your chance to drop it in the chat. Thank you so much, Pauline. I already know all the good information that you keep sending us. And Good Lawyer is really a great platform to check out. Like Pauline says, you can get $100 credit, and you should sign up. If you need the link, you can go to the Canadian Small Business Women page, go to the partner tab, and they are on the partner page. I will also be posting this probably to YouTube and let it sit in the description with a link where you can connect with anyone at Good Lawyer. And yeah, I'm trying to think of anything else. I felt like there was something else I was going to say, and now I don't remember. I don't remember.
It happens to the best of us.
It sure does. The replay will be available on this platform as well for the next, I think it's set at 12 months. If you have any questions, please feel free to reach out to us and ask, because I will definitely get the questions, Pauline. Thank you so much, Pauline, for all of this. I don't see any questions in the chat right now, but I think they need to watch the replay and absorb some things. So thank you, thank you, thank you.
Thank you so much for having me. I hope everybody got something useful out of this. Hopefully I didn't blast you with too much information, but like Dwayne says, you can always go through and slowly sort of absorb it in as you go for the next 12 months.
Perfect. Well, everyone have a wonderful rest of your Thursday. To think about what day it was. And feel free to reach out to Good Lawyer. I will follow up with an email with all of you registrants so that you know where to find Good Lawyer and Pauline. Bye.
Thank you. Bye.